you I request each member to please switch on the cameras. Please everyone kindly switch on the cameras.
Good evening, all. To honor us, we have with us today Honorable Justice A.K. Sikri. I welcome you all. I welcome you, sir, in this special session. We'll be starting in a few minutes. We're just waiting for Honorable Justice Balakrishnan.
Good evening, everybody. Good evening, sir.
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 Good evening,
Good evening,
sir.
sir.
Good evening, sir.
Good evening, sir.
Thank you all. We also have with us Honorable Justice K.T. Balakrishnan. We welcome you, sir, to the special session of our e-seminar on life, liberty and privacy. I would request everyone to please switch off their microphone. All the participants are requested to please mute themselves.
Good evening, Chief.
Good evening. Good evening.
How are you, sir?
Fine.
So confined to home?
I'm at Cochin.
Oh, you are in Cochin. No, Cochin, up to now situation was good. Now for last few days, Kerala also situation is going out of control.
Yeah, no. These are all mainly the media.
Yeah. I know that is also there.
It's
Yes.
only 15, 20 and all.
Yeah.
Compared to Delhi, there is nothing.
That's right. Justice Radhakrishna is also there only. We had one arbitration yesterday, so he joined from Cochin.
I am also doing some arbitration from here,
Uh-huh.
but the only problem is the records are in Delhi.
Yeah.
Good evening, all. Our world is currently experiencing a number of rapid changes that were perhaps unimaginable a few years ago or even a few months ago. We lost the early part of the year 2020 planning how to deal with this man-made disaster, COVID-19. The world, at present, is battling with the challenges this virus presents to us. A considerable portion of the year has already been lost, and the situation is still not very clear. As a matter of fact, we all have now accepted that with changing dimensions, we have to be adaptive and we have to adopt the new norms. But the bigger question is, what exactly are the new norms? Are we really clear on it for all sectors? As a member of the legal fraternity, I, Abhishek Chaudhary, the founder of Legis Orbis, at least can say the new normal of the legal education system in India is not so clear. Yes. In order to respond to the situation, understanding its graveness, the agencies, the boards, the councils, and the concerning authorities have come up with various guidelines relating to the conduct of the examinations, promotion of the students, and formalities relating to the award of the degrees to the graduating students in 2020. The area that's still left unaddressed is the academic loss suffered by the law students in India since the imposition of Lockdown 1. The day our union government announced the preventive lockdown measures, a wave of uncertainty and speculations gripped the legal community. Understanding the immediate need to match the requirements of the day and to contribute to the society in preventing further academic loss by the law students in India, we came up with the noble initiative of Legis Orbis in India. In less than 48 hours of our launch, we received registration from 150 law students from 67 different campuses throughout the nation for the first phase of our online live classes. In the first month of our inception, we conducted our first webinar series on career opportunities for the law students during and post pandemic phase, wherein we invited various legal luminaries to address this session, which received participation from 500 plus students from various parts of India. We truly acknowledge the dynamic nature of legal education and support the vision of Bar Council of India with regards to the continuing legal education. At Legis Orbis, we are conducting various curricular activities, including inter alia, webinars, e-seminars, quizzes, blog writings, article writings, online moot court competitions, etc. Legis Orbis is now offering online education in more than 10 subjects with the help of 10 plus expert mentors under the able guidance of our advisory board, which is chaired by Sri Salman Khurshid, International Supreme Court of India. The three core mission of our organization are education, research, and social contribution. Research and social contribution are necessary in order to pose a justified response to the global trends, which is ever changing. Education, on the other hand, has an essential nature that I truly believe to be unchangeable. With these missions in our mind, we dedicated Legis Orbis to the entire nation, where academic interviews have proceeded undisturbed even during the pandemic. During this phase, when everyone is dealing with the struggles of their life, we have come up with an idea which would contribute in sharing of problems from their shoulders to ours. And thereby, we are making a positive contribution towards a positive nation building. What we are trying to show that despite all negativities prevailing around due to pandemic situation, we all can contribute in making a positive environment. And the idea of Legis Orbis is a prominent example. What we started as a mere idea has now received the cooperation and recognition, not only from the bench, the bar, the academic institution, the corporate houses, the law firms, but the society at large. What we are witnessing today and what everyone witnessed over the past few days is a display of what can be done with sheer amount of dedication, commitments, and hard work. Today, I feel proud to announce the successful conduct of India's first and the biggest e-seminar titled Life, Liberty and Privacy, the Indian Jurisprudence on the Individual Data Privacy in association with LexisNexis. To our honor today, we have with us Honorable Justice K.G. Balakrishnan, former Chief Justice of India, and Honorable Justice A.K. Sikri, former Judge, Honorable Supreme Court of India, and presently International Judge at the Singapore International Commercial Court, to address the valedictory session of this e-seminar. I, on behalf of the entire Legis Orbis family, welcome His Lordship, members of the bench and bar present with us today, legal professionals and academicians, paper contributors and participants, and students of law who has joined and connected with us electronically here in this session and our live YouTube feeds. I would now request our co-founder, Ms. Ritika Ritu, to deliver the opening remarks. Thank you.
Good evening, all. Ours is an age of information, more particularly electronic information. No doubt, even today, information is knowledge. But technology is more powerful as it has practically and fundamentally interconnected life of individuals. Internet has taken over everything, and metaphorically, it can be termed omnipresent. Even today, when Legis Orbis is hosting its first and India's biggest e-seminar in association with LexisNexis, it's yet possible because of the technology and the internet. Internet not only aids the free flow of information, but also connects people, provides a platform for e-commerce, e-banking, e-trading, e-reading, e-booking, and e-education. Unsurprisingly, it comes with uninvited problems as well, as every transaction performed with the help of internet leaves electronic tracks generally without the knowledge of the user. These electronic tracks contain data and information which provides insight on the kind of person the user is and their interest. Precisely, this information gives a picture of the being and the things that matter and therefore raises privacy concerns that depict serious issues in the age of information and technology, more particularly in democracy where the right to privacy has taken the shape of fundamental rights by the virtue of judicial activism. The uniqueness of the constitutional jurisprudence could be evidenced through the extended dimension of Article 21 of the Indian Constitution. Right to privacy is one of those rights which have come into existence after widening the purview of Article 21 of the Constitution of India. Initially, the Constitution of India didn't guarantee the right to privacy, but the Honorable Supreme Court of India, in order to articulate and enforce what is beneficial for the society in general and people at large, through its landmark judgment delivered on August 24, 2017, in the case of Justice K.S. Puttaswamy retired versus Union of India, enforced the right to privacy of 1.3 billion people as one of the essential fundamental rights. The Honorable Apex Court, while delivering the Puttaswamy judgment, not only overruled its earlier two decisions of MP Sharma versus Satish Chandra in 1954 and Kharak Singh versus State of UP in 1962, which had held that privacy was not a fundamental right. It also declared that right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution and as a part of the freedoms guaranteed by Part 3 of the Constitution. The judgment of K.S. Puttaswamy has an incidental implication on the complex relation between the personal privacy and the big data, particularly in the context of how the judicious use of these technologies can result in the state achieving its legitimate interest with greater efficiencies. This case has recognized the impact that non-government entities can have on personal privacy, particularly with respect to information privacy on the internet. While it is very clear that fundamental right could be enforced only against the state, looking at the broad language of this, the various experts have stated that it could be extended to private sectors as well. This judgment has definitely widened the regime of right to privacy and is definitely going to bring a large number of sectors infringing the privacy laws within its purview, with the aim of achieving a fruitful discussion among legal luminaries, academics, members of the bench, the bar, and enforcement agencies during the proceedings. Legis Orbis conducted the first of its kind e-seminar in India, which received massive participation from entire legal fraternity. The inaugural session was addressed by Honorable Justice Kurian Joseph, former Judge Supreme Court of India, and Professor Dr. R. Venkatarao, former Vice Chancellor, National Law School of India, University, Bengaluru. Over the past 3 days, we conducted 3 intellectual sessions wherein more than 40 participants presented their papers and articles using our virtual platform. The themes chosen for this e-seminars are as follows: Privacy and Data Protection Framework, the Indian Contact Tracing App Aarogya Setu, Biometric Identification in India, the Aadhar Charter and the Fundamental Right to Privacy, Protection versus Privacy, the Expanded Surveillance Scheme. Doctrinal shadow of the Indian Constitution over the right to privacy in digital India. I thank each one of you who participated in this e-seminar and contributed in making this event a grand success. I also thank our revered guests for giving their kind concern to address this e-gathering on the issue of changing dimensions of right to privacy in India. I would now request our co-founder, Ms. Rajeshri Kanungo, to introduce and welcome our honorable guest for the evening. Thank you.
Good evening, all. I feel privileged and honored to welcome on behalf of the entire Legis Orbis family our revered guest for the evening, Honorable Justice K.G. Balakrishnan, former Chief Justice of India, and Honorable Justice A.K. Sikri, former Judge, Supreme Court of India, and presently International Judge at the Singapore International Commercial Court. Honorable Justice K.G. Balakrishnan was born on 12th May 1945. His Lordship got enrolled as an advocate with the Kerala Bar Council on 16th March 1968 and practiced on both the civil and criminal sides at Erinakulam. His Lordship was appointed as a Munsif in the Kerala Judicial Service on 10th January 1973 and later resigned from service and resumed practice as an advocate in the Kerala High Court. On 26 September 1985, Millard was appointed as a judge of the Kerala High Court. On 24th November 1997, his Lordship was transferred to Gujarat High Court, wherein he became the Chief Justice on 16th July 1998. His Lordship was transferred to the High Court of Judicature of Madras, wherein he assumed charge as the Chief Justice on 9th September 1999. On 8th June 2000, Honorable Justice K.G. Balakrishnan was elevated as the Judge of Honorable Supreme Court of India and was appointed as the Honorable Chief Justice of India in the forenoon of 14th January 2007. Honorable Justice K.G. Balakrishnan retired on 12/5/2010. Honorable Justice E.K. Sikri was born on 7th March 1954. He had excellent academic record as he stood third in the merit list in higher secondary from CBSE Delhi. His Lordship did his BCom honours from Sri Ram College of Commerce, Delhi University in the year 1974 and LLB from Law Faculty, Delhi University in the year 1977. His Lordship was awarded gold medal for attaining first position in LLB. He was awarded special prize for getting highest marks in Constitutional Law 1 and 2. Honorable Justice Sikri had distinction of securing first position in all 6 semesters of LLB and getting all possible prizes and medals of Delhi University for LLB course. He did his LLM from Delhi University and got first position in 3 years course and also won medals and prizes in various extracurricular activities. His Lordship enrolled as an advocate in July 1977 with the Bar Council of Delhi and started practicing in Delhi, wherein he conducted cases of all types with specialization in constitutional cases, labor, service matters, and arbitration matters. Honorable Justice Sikri was designated as senior advocate by the Delhi High Court on 30th September 1997. His Lordship was appointed as the Judge of High Court of Delhi on 7 July 1999. He was chosen as one of the 50 most influential persons in intellectual property in the world in the survey conducted by Managing Intellectual Property Association for the year 2007. His Lordship became the acting Justice of Delhi High Court on 10th October 2011 and was elevated as the Chief Justice of Punjab and Haryana High Court on 23rd September 2012. My Lord was elevated to the Honorable Supreme Court of India on 12th April 2013. Honorable Justice E.K. Sikri has been conferred Doctorate of Laws honoris causa by Dr. Ram Manohar Lohia National Law University, Lucknow in November 2013. His Lordship retired on 6th March 2019 and Honorable Justice E.K. Sikri is presently the International Judge at the Singapore International Commercial Court. I welcome Honorable Justice K.G. Balakrishnan and Honorable Justice E.K. Sikri to the India's biggest e-seminar on the right to privacy brought to you by Legis Orbis in association with LexisNexis. I now request Honorable Justice E.K. Sikri to kindly address the August e-gathering.
Thank you, Rajshri, for your such a benign, I would say, introduction.
Welcome.
And with all these compliments, my good evening to my Chief Justice, Justice Balakrishnan, whom I see after such a long time, and that too only on a virtual platform. My congratulations to the team Legis Orbis for I would say utilizing this COVID time. These are very difficult times, but utilizing these times in a most meaningful manner, to which I'll address a little bit later on, and all the participants who are attending this webinar and this valedictory session, which is organized now. Let me again, as I said, start with congratulating Legis Orbis. As I was thinking, ever since the lockdown started, and we were all confined to our homes. Of course, now lockdown is no more there. When it was partially removed, you young people could still go out, but person like me and Chief Justice Balakrishnan, we even thereafter are advised not to go out. We are in that zone. But then how people started utilizing their time when you are 24/7, you are confined to your houses. The great savior was the technology, no doubt about it. And this technology has been utilized by people in various ways. There have been young generation who have utilized the technology by having access to our Netflix, Amazon, the streaming so many movies, etc. Even Airtel stream and YouTube. So you are listening music, and you have you can spend so much time in all these activities. People were getting bored also, but then there is another flip side of it, and there are many, and to that category you people belong, who decided that yes, let us make use of this technology, but in a better way, in a more productive way. And that is how, as I understand, you conceptualized this legis orbis, started this, and the way you have been doing not only the e-classes, online classes, etc., for youngsters, students, and young lawyers also, but then thereafter these 5 days e-seminar on such an important topics. So therefore, that is one reason I say that yes, the manner in which you have been, this is really outcome of a productive mind, that you should not only gain yourself, but in the process you are spreading the education, you are spreading the awareness. You are, even when these budding lawyers, young students or young lawyers, they are confined to home, you're telling them that how you can still utilize your time, and you can hone your skills, and tomorrow you will become a great lawyers because of that. So this is one thing which is not only a philanthropic activity on your part, and but otherwise also really, really with humane touch. And for that I say that I really congratulate you. As I see the faces, because I have been talking to you persons only on phone, but you are all young faces. And another thing which I saw from some of the persons, apart from Mr. Abhishek Chaudhary, who is the brain behind it, but the other persons who have supported, and I see Ritika Ritu, who is there, and Rashiri Kanungo. So at least I share with them the same educational milestones which they have achieved. They also, both of them are gold medalists in law, and as Rashiri told, I also could get that. So therefore, there could not have been a better way of uh, utilizing this time, and having a seminar on such an important topic. Now, you see, if we may go back as before coming to this topic and right to privacy, as I have seen that the four topics which were chosen, and which have been the introduction whereof had been given uh, by Ritika. So they are all very, very important topics, and they all touch different aspects of privacy. Now, as rightly said, in Puttaswamy case, in this judgment, this is now finally established. There was a controversy. There were few judgments which said that privacy is a fundamental right. Few other judgments which have been overruled now, and which he mentioned that privacy was not a fundamental right, because it is not contained in any of the provisions of fundamental right, thus Part 3 of the Constitution. uh, what my hypothesis is, and if I start with that, uh, of course, we have a chapter on fundamental rights, part 3. It contains so many rights therein, and privacy is nowhere mentioned. But likewise, there are many, many other rights which are recognized as fundamental rights today. There may be different facets by it's the creation of the Supreme Court, like in as far as right to privacy is concerned, even those rights, that they may not be there exactly in one form or the other, but by interpretative process, they have been held to be the facets of so many other rights, particularly Article 21 of the Constitution, which talks of right to life and liberty. Such an expansive and wide meaning which is given to life and liberty, and many rights, and today if you count, as many as 40 rights have been created out of that, which is only right to life and liberty. And if one may go by the grammatical or literal meaning of right to life and liberty, And when it says that nobody, that no person shall be deprived of his right to life, life and liberty except by process of law, one only gets an impression that this is right of my freedom, and it only relates to my freedom, that I should not be deprived, I can't be put to jail, my life cannot be taken away except by the process of law. That is, if somebody has committed a crime, and that for that crime he is tested in by the court of law and found guilty, and for that he is punished. So, but the meaning which is given to life as well as liberty, as I said, and it is not to be, this is not an occasion to expand that, and all of you know, is given. But what is my hypothesis into that? And that becomes very relevant insofar as when we come to right to privacy, that most of these rights, particularly under Article 21, which have been created as facet of 21, maybe 19 also, 14 also, because as when we come to right to privacy, the Supreme Court has said that it is not only traceable to Article 21, but all 14, 19, and 21, all three are there. Some of the other facets of all these three, those traces are there in right to privacy. But what I'm trying to say is that these wider meaning and expansive meaning which is assigned to all these rights, and these rights are created, they flow from what, and that is my hypothesis on which I have been saying so, I have said so in some of my judgments also, they flow from one particular aspect, that is human dignity. Dignity in that way becomes very, very important. And if you see, very interestingly, dignity is nowhere in any of the provisions of the Constitution. There's only at one place the word dignity is stated, that is in the preamble of the Constitution. That word comes. But if you see the judgment right from 1950, but particularly after 1975, 1977, 78 onwards, and many rights which were created, they have been, and if you see the judgment in 78, 79, the judgments given by Justice Krishna, Justice Bhagwati, Justice Chinnappa Reddy and others, and Justice Chandrachud, Senior Chandrachud. So all these judgments, they will, you will see from that, that word dignity is mentioned there. From where, if you find the rights of, say, even those who are criminals, judgment in Sunil Batra case, D.K. Basu case, judgment in Francis Moylan case, where different rights were given, they all flow that, look, if merely because a person is convicted, that doesn't mean that you have taken away his dignity. Likewise, in recent times, and even thereafter it has started, you see the women's rights. Now, when we come to triple talaq, we come to Sabrimala judgment. I'm talking of recent judgments, and you see the rights of persons suffering from disability, and they are all based on Jija Ghosh judgment is there, and there are so many other judgments there which talk of dignity in particular, and euthanasia judgment again is that judgment, and even the person's right of autonomy, which is Selvi's case, where that you can't subject a person even when he or she is a criminal to narco test, etc., against their wishes. So they all flow from the concept of dignity. And dignity, how it is treated, but of course initially in the earlier judgments, if I say till 2013 or 14, dignity as a concept, dignity was mentioned, but as a concept it was not defined. But the Supreme Court started defining in what way we will accept this dignity. Of course, let me tell you, of course, this dignity has been mentioned insofar as UN Charter is concerned, and the UN human rights are concerned. So there it is mentioned, and there are specific provisions about that. But as I said, from 2013-14, the it is conceptually and jurisprudentially the dignity has been developed, and and which you will see it would be mentioned, and it has been explained in all these recent judgment which I have shown, and it has been thereafter explained in such a brilliant way and in such a I mean wider manner jurisprudentially in Puttu Swami judgment. And I would say therefore all these rights, including the right to privacy, they are based on dignity. And the basic concept of dignity is that you respect one's capacity as an agent to make one's own choice, free choices. I'm a free person. What I want, that should be my choice. If I say you in a very simple term, and which others, even a common man would understand, the movie Three Idiots, which was entirely based on that. Even parents should not impose their choice on the children. They have a right to grow. They have a right to adopt their career, whatever they want, because they are attuned to that. And so that is how we grow. That is, it's not only career, but our own, personality also, which is to be grown. So therefore, I have right to make my choice. And another aspect, the other should respect my choice which I have made. And respect also need to have the context and the conditions in which the choice is made. So this was actually explained in a much lengthier way in the first transgender judgment, when we talk even of transgenders, that they have a right to live that kind of life, and we have to recognize that. And of course, I can take say that in that judgment, which was main judgment, was given by Justice Radhakrishnan, and I gave my concurring opinion on that. So because I didn't want to say so much which so brilliantly Justice Radhakrishnan had explained, but then I introduced the element of dignity into that. Even dignity is of transgenders. So when, therefore, in this context, when I come to this uh, when we talk of autonomy, we talk of personal choice, and which has to be respected, and so it can't be traded with the right to privacy comes. So what I do in my private life and what I want to do, that is nobody else's business, and that has to be protected. This is what I say is the fulcrum of the entire judgment, which is 9 judge bench judgment, which was again explained in the 5 judge Puttuswamy 2 by the 5 judge bench judgment. And so therefore, uh, once it is accepted, and another aspect which was very important aspect in Puttuswamy judgment which was given was that, and once it is accepted as fundamental right, then it is possible, because Article 19 also says from 2 to 6 that there can be reasonable restrictions. But then reasonable restriction, what is the reasonability? Of course, again, reasonable restriction have been explained earlier also in so many judgments right from 1950. But from these judgments, the concept of proportionality, in that sense, proportionality was also there, but which was again highlighted and jurisprudentially developed. That, of course, in public interest you can do so. There may be the interest or the rights of other persons also. So there may be in a way conflict of two fundamental rights even. But then the balancing comes, and how you have to do that balancing. And in that balancing, the doctrine of proportionality has to be adopted. That, first of all, any inroad to that right of privacy has to be backed by law. That is what Article 19 says. It can't be by any administrative instructions, etc. Then it has to be in state interest, in the interest of state, and it has to have some objective behind that law, which by which you are trying to infringe the right of a person, or making inroad to that or exception to that right to person. And fourth, which was most important, was that minimal interference, which is absolutely essential. The moment you go little beyond that, then even if the law is there, Supreme Court will strike, or even the High Court have right to strike down that law. So this becomes very important. Entire right to privacy has to be seen in that context. And therefore, the good thing was that in these judgment, it was suggested also, particularly in Puttuswamy both 1 and 2, that once we talk of right to privacy, and therefore data protection is becomes very important. Whatever is my data, and that too again having regard to the technology which is there. And even if and this data protection has to be at two levels or in two spheres. One is state. The government or the state should not be in a position to misutilize my data, and it may not turn into a surveillance state. So therefore, provisions which are in the particular act, because law is made, they have to be tested from that angle. So other part of data protection, even the private players, like we know today, we are all on say Facebook, WhatsApp, we are using that, Google, etc. And the moment we use that, and I need not again elaborate, you people are much more technically savvy, you know that our data is available to these servers. Actually, nothing comes free, as I always say. Maybe we are utilizing all these, whether it is Google or YouTube or Facebook or WhatsApp, free. But then our data is being used by them because our data is available to them. So therefore, what becomes important is that there has to be a law regulating this data so that my privacy is protected. And the need to law, of course, good thing is that uh, the executive or the state has realized that. They have come out with a bill on data protection. The bill has been discussed. It is now given to the that standing committee headed by Minakshi Lekhi, and there are about, I think, 30 persons there in that. They are examining various provisions. They have invited suggestions. Even I have sent many suggestions in respect of some of the provisions there, that how they should be tweaked with. But what I say, that during COVID times, again, this has become, the data protection has become again a very, very important subject, and privacy has become a very, very important subject. And it is being discussed that which is that Setu, that uh, with the government has, Aarogya Setu. Yeah, Aarogya Setu. So whether it infringes my right to privacy. On the one hand, again, that balancing comes. On the one hand, it is needed in the interest of the country, in the interest of the health of the people. On the other hand, it is my privacy also. So, but then, therefore, need to protect the data is there. Need is the, it is very necessary that it has not to be misutilized, and particularly in the case of Aarogya Setu, when it is going in the hands of the government. So therefore, I hope that this committee which is looking into this, the new issues, or so many issues which have emerged because of COVID-19 situation, they will also be taken care of, and the report which they submit would come in a better form. With this, I let me congratulate again this Legis Orbis for organizing this seminar, and another venture which you are coming out with, since you had held a competition, essay competition on these topics also. You must have got brilliant I mean essays on this, and you are going to come out with a book. So I would like to read all those essays to enlighten myself, because everybody, the knowledge should come from everywhere, from wherever it comes. As I said, now sunshine is welcome from wherever it comes. With this, I congratulate, and I those who are going to get, or those who are getting prizes, my congratulations to them also. Thank you very much.
Thank you, sir, for enlightening us. I would now invite the Chief Guest of the evening, Honorable Justice K.J. Balakrishnan, the former Chief Justice of India, to kindly address the August e-gathering.
Honorable Justice Sikri, the organizers of this seminar, the Legis Always, Mr. Abhishek Chaudhary, Rajashree, Ritika, and their colleagues. It's a very good idea to start and spend time in this COVID situation. I'm happy that you are making use of your time brilliantly and encouraging the members of the legal fraternity to the best of their use and ability. And you have chosen the right to privacy. Mr. Justice Sikri has elucidated the subject very, very succinctly and clearly. What is the contribution made by the Supreme Court? What is about the private this right to privacy, how it is evolved as a fundamental right. All fundamental rights are directly not stated in the fundamental rights chapter, but not only this, the right to education was not stated directly in the fundamental right. All these, some of the very valuable rights which were stated in the directive principle state policy has now become the fundamental rights. So that is how the law is developing. The constitution, especially constitutional law, is a dynamic thing. Various interpretations are given. I recently came across a comment by an American jurist, Valedictory. He said, a written constitution should be viewed as a living tree with roots in precedent and community's constitutional morality. Tree that has branches and grows over time, evolving common law jurisprudence. So the constitution law will evolve new theories, new dimension. Is Article 21 itself has been given. You know, there was earlier a decision, Eka Gopal's case, the Article 21 was narrowly interpreted. It was the procedure, the Article 21, personal liberty, except according the no one shall be deprived of his life and personal liberty except according to the procedure established by law. The procedure established by law should be reasonable, free from all this wider interpretation was given in Maneka Gandhi's case. So that is how the law developed, and more Article 21 has been given very wider interpretation. So all the rights, important rights, could be claimed under the provisions of the Article 21. It is a very big constitutional development, and we have taken these right to privacy, which is now considered as a very important right, and the internationally also. The Article 12 of the Universal Declaration of Human Rights, that is, it is stated, no one shall be subjected to arbitrary interference with his privacy, family, or correspondence, nor to attack upon his honor and reputation. Everyone has the right to protection of law against such interference or attacks. So, the Article 17 of the Civil and the Covenant on Civil and Political Rights also is in the same line. No one shall be subjected to arbitrary and unlawful interference with his privacy, family, home, and correspondence, nor to unlawful attacks on his honor and reputation. So the international law, we adopted, we accepted the protocol of Covenant on Civil and Political Rights. So we are also in a way bound by these statements made in these international documents. So we are following these right to privacy as a very valuable right, and it has been explained in detail in the Putsami's case, and later, earlier case also, this was not descended on, but it was correcting also the night surveillance was deprecated by Supreme Court. That was, though it was as such was not declared as a fundamental right, this right to privacy. But it will assume more and more significance in this time when our data protection is very, very, very essential. And naturally, as Justice Sikri has pointed out, all these WhatsApp, Instagram, these YouTube and all, many of the information we unknowingly pass on to these type of communication system. So once these communication system, the data are available, it is likely to be misused. Whenever the state also compile our details, even for distribution of ration or other benefits, pension or anything, the state must naturally collect the details of the individual. it has in a way helped the state to prevent the unauthorized or corruption or unauthorized persons getting the benefit of the state benefits. That is why it is said that there were large number of unauthorized ration cards. But once this was clubbed to the Aadhar card,
We are having some technical issues.
Yes, some technical, I think, at Justice Balakrishnan's level. Yeah.
Indeed, sir. That's true. Will you please connect with sir?
Give me a minute.
This is the flip side of technology. I think he's disconnected. He's not there.
No, sir, he's not there.
Like some network issue, I guess, because number is unreachable.
Yeah, it is network issue. I know.
With your due permission, your lordship, we can take a few questions at this moment by the time Justice Balakrishnan again joins us. The first question that has been asked is the main purpose of data protection bill was to incorporate data protection principles and also ensure accountability of government use of data. In your honor's opinion, does the PDP bill meet this threshold?
As I said, although briefly in my comments made earlier, uh, the provisions and the bill, which is the way it has been drafted, maybe it does not take care of all the I mean apprehensions of the people insofar as data protection is concerned. And as I said, that this data protection has to be, it's not only uh, I mean the misuse of data can be private persons, misuse of data can be by the state. Insofar as private persons are concerned, as I named you all those companies, etc., their purpose is commercial, because they will collate that data for the purposes of what are the choices of people, which product is more in demand, and if I'm flying, which particular lines I take, airlines I would be taking, if I'm staying in hotel, which particular hotels I'm staying, and of course my private I mean life can also be that way. Data can be used, what ailments I'm suffering from, what kind of treatment I'm getting, etc. But then they would use it for their commercial purposes. They will sell that data to those who may be needing it. Insofar, when it comes to misuse of data by the state, that may assume very dangerous proportions, because then any state may lead to surveillance state, and surveillance of people, and then nailing the people because of by surveilling it is anathema of our liberty, the very concept of the social contract on the basis of which all these democracies are made, or our democracy also, and the basic features. And the very privacy goes if that is misused. So therefore, there have to be very, very strict and very clear provisions which put the safeguards of misuse of data on these fronts. Of course, there are provisions in the bill which say of how the data has to be anonymized, so that it is not used, and at least the person who is whose data is used even for benevolent purposes, it is not known whose data it is. But then, having said so, and even if those provisions are there, but the misuse of provision cannot be ruled out. And technology today has gone to the extent, even when the particular data is anonymized, still the process can be reversed, and we can still find out. Even if it is encrypted, we can disencrypt that also, even when all those. So therefore, how to take care of that, that becomes very, very important. And according to me, that has to be seen, that has to be examined, and all proper provisions have to be put into that. There are some you see, some of the European countries, like not European, EU has already come out with this. Even Singapore has come out with the laws. And there are some provisions which are in those laws which may not be there in the Indian bill, which has been there. And there, I think, and there are many ones. They have, as I said, that the select committee has invited the comments, etc. Many must have written that these are the provisions in the other laws which should be included and taken care of. Let us hope that that should be done. But in the present form, it may not suffice the purpose. I agree with that. Unmute yourself. Mr.
Apologies, Your Lordship. Your Lordship, the next question is, when the Supreme Court held privacy to be fundamental right, whether mandating the compulsory uses of Aarogya Setu app for undertaking the air travel in India violate our fundamental rights, especially the right to privacy?
You see, again, although I touched upon that myself, and the entire Aadhar judgment is also based on that. That there could be, now today there may be two rights, or two, I would say, public interest, because the doctrine of proportionality, it says that any invasion into the privacy has to meet the test, and in the balancing test, the test of proportionality. And the test of proportionality is devised, that balancing is when there is a conflict, that whatever is absolutely essential is done, and and you have to see the balancing, that yes, even if there is a public purpose, that public purpose doesn't go to the extent of taking away what is absolutely essential, not beyond that. And if you remember applying this test in Aadhar judgment itself, while upholding Aadhar as per se as a scheme, many provisions could be declared unconstitutional because they were not meeting the test of proportionality. Now, applying that test, of course, since the matter is pending in the Supreme Court, I would not say more. But then the question is, yes, COVID-19 situation, it is a pandemic. If this is declared as pandemic not by India, but yeah, Justice Balakrishnan has come, so we can ask him to review.
Sorry for the inconvenience. There was a net dislocation. So I have almost completed the fundamental rights, which is the right to privacy, has been now given more importance. Let us see the developmental law, how it will. Actually, a bill, some private bill is pending, and personal data protection bill of 2018 it may come before the parliament, but as usual, private bills are not normally it comes as law, but it will later the government itself will has to codify this law, to protect the, otherwise more and more disputes will come to the court, litigation will increase, that is not a desirable thing. So the personal data protection bill or similar enactment will come soon, then that will help the people to protect their rights. Now the intellectual property is assuming more and more importance in this era. So I am happy that the legislature has selected this subject, and more important subject you should come forward, and we shall keep alive the young lawyers active, deeply interested in all matters, so that their interest shall never go to the bottom. It shall be always alive. We all will be, so long as we are healthy, we will continue to cooperate with all of you. Any classes or any matter, we will be ready. Helpful. Very, very happy to see Justice Sikri, at least in this virtual form. Thank you. We'll meet soon, and hope to meet all of you. Thank you. Thank you very much.
Much obliged, Your Lordship. Continuing with our question and answer round. Your Lordship, the next question is, recently Government of India has banned 59 apps because it corrupted and affected the privacy of the citizens of India. So also as safeguarded the sovereignty and integrity of the nation. How privacy of an individual can affect the sovereignty and integrity of the nation?
So the question is by I have to answer.
Indeed,
The sovereignty and integrity is affecting when these rights are misused by undesirable people to cause damage. Either it could be in different form. We cannot envisage that not under normal circumstances it is not likely. But there are people who make use of these these mechanisms, for undesirable thing. That is why the state has to protect the interest of the whole country. That is why it is done. We cannot, unless it is very thoroughly examined by people, eminent people who is conversant with this matter. We cannot simply give an answer that it is neither good or bad. So it all depends on various factors.
Your Lordship, the next question is, India is currently the only democratic nation in the world that has made the app mandatory for people. This is in reference to the Aarogya Setu app, definitely. What is the legality of making this app mandatory?
But Justice Sikri will answer.
Okay. I think you see these orders, as I said, since right to privacy is a fundamental right, any invasion in that right or even taking away a part of that right, it has to be backed by law. So it cannot be by any administrative instructions, etc. There has to be a law in that. But in this case, it is done, under the Disaster Management Act. So therefore, that act and the earlier act of that 1800, which is that name of that act, although archaic act, yes. So therefore, the law is shown. That is the law. I was about that. Aarogya Setu. The matter is pending in the court, and I was explaining, the balancing is to be done now by the Supreme Court. That would be the question before the Supreme Court. On the one hand, as I was saying, it's a pandemic declared, and it's a pandemic not declared by India only. If the pandemic means, then the situation is worse. This become epidemic worldwide. And it is WHO which has declared. So it is not that the Indian government is riding on that. So pandemic situation we have to accept. Today, the position which is happening and the way it is worsening, we have already crossed 12, 13 lakhs, almost now 47, 48,000 cases coming every day. Now, we have reached those proportions and we don't know where we are heading. And what we know about the COVID-19 today is that we don't know anything. That's the only thing we know. And it is totally uncertain. And therefore, the government, as a welfare state, is supposed to take measures to control that. This becomes the duty. It is the expectation of the people also that it is the duty of the state. So on the one hand, it is the duty of the state because of which state is taking so many measures, which includes Aarogya Setu as well. This is one of the measures. So therefore, if you see in the, uh, this Puttaswamy judgment also, if I may tell you, the test which was laid down, the 9-bench judgment, interestingly, Justice Chandrachud, who wrote the majority judgment, he said legitimate state interest. That the law should be, and the words which are given is legitimate state interest. On the other hand, Justice Kalmeshwar and Justice Sapre use the expression compelling state interest. Now, legitimate state interest would be different from compelling state interest because compelling state interest means it threshold becomes much higher, much more difficult. And Justice Paul, on the other hand, use the expression public interest only. He didn't say legitimate or compelling, but only public interest. And again, when it comes to public interest, then there are different parameters. And Justice Nariman used the expression larger public interest. So therefore, 4 expressions was used in that judgment. But then in Puttaswamy 2, 5 judgment, when it examined that, then it held that, look, which test is to be applied? Ultimately, we said that Justice Chandrachud, since that is a majority judgment, so therefore that becomes the law, and therefore legitimate state interest, which was a test laid down by the judgment authored by Justice Chandrachud as majority judgment, so that is accepted in Puttaswamy 2. So therefore, in examining this issue, Supreme Court will today go by the test of legitimate state interest. So once it comes to legitimate, now state interest is there. There's no doubt about it. The checking corona virus is in state interest. Nobody can say though. It is public interest also, whether to call it public interest, whether to call, even I think when we use the expression of compelling state interest, it would even fall in that higher threshold also. State interest is there. Today we have to take measures to control this pandemic. And so that is one thing. Now the only thing which that arises is, as I said, when this balancing is to be done, there the court had laid down the principle that we have to see on 4 parameters. Number 1, it is designated for a proper purpose that it serves. Number 2, the measures undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. So this Aarogya Setu is also connected with that. There is no doubt about it. The number 3 is the measures undertaken are necessary in that there are no alternative measures. Now this is very, very important. Whether there is any alternative, because we are impinging the right of privacy. So if there is an alternative, then we should not adopt it. That is what in Puttaswamy 2 in Aadhar was followed, and many provisions, as I said earlier, was struck down. And 4th, now 3rd and 4th will become the matter of controversy before the court, if I say so. 3rd is no alternative. So court people will come out that there were alternatives. If there were, they should have been used. Then number 4 is there needs to be a proper relation, proportionality stricto sensu, or balancing between the importance of achieving the proper purpose and social importance of preventing the limitation on the constitutional right. So this balancing means that what is taken is, or what measure is adopted, not only that there is no alternative, but to what extent you have gone, whether it was necessary to go to that extent. So matter will have to be, today I will rest at that only, will not make, because in the matter is pending in the Supreme Court. Let us see what way Supreme Court undertakes this exercise. But this is going to be the argument, then this is my analysis. Yes.
Your Lordship, the final question of the evening. The pandemic has led to an era dependent on technology. We today have connected ourselves with the help of technology only. Do you think all the social media apps and platforms should be available for public after they meet few authorizations or after passing the privacy impact authorizations of the state, of course?
I think the second alternative would be better alternative, no doubt. If we have to again, protect the privacy, or there has to be data protection. That is what I feel. That is what we have been discussing all this, all through entire session. Yes.
Much obliged, Your Lordship, for answering all the questions of the user. Unfortunately, due to time constraint, we are not able to take more questions. Moving ahead, announcing the best papers. We call for papers as a part of this seminar in two categories, the professional category and the student category. We received almost 40 papers which we have selected and will be publishing in a special edition book which will be launched on or before 15th of September 2020. The best paper for this professional category has been achieved by Riti Tripathi, Civil Judge on Probation, Odisha Judiciary. The special mention goes to Mr. Ashit Kumar Srivastav, Assistant Professor of Law, National Law University, Jabalpur. For the student category, we have selected the best paper of Ms. Kajal Priya, an LLB student of National University of Study and Research in Law, Ranchi. And the special mention goes to Pranita Raj, a BBA LLB student of SOA National Institute of Law, Bhubaneswar. I may now invite Ritika Ritu to propose the vote of thanks.
Thank you very much, sir. It's my privilege to have been asked to propose a vote of thanks on this occasion. I would like to extend my hearty vote of thanks to His Lordship, Honorable Mr. Justice K.G. Balakrishnan and Honorable Mr. Justice A.K. Sikri for accepting our invitation to this e-seminar and addressing the e-gathering today. We are definitely enlightened with the words of wisdom from our revered guest. I would also like to take this opportunity to thank Professor Dr. Jaydev Pati, former principal, MS Law College, and current legal advisor of SOA National Institute of Law, SOA University, Dr. Madhubrata Mohanty, and Mr. Prabhu Prasanna Behra, Advocate, Orissa High Court, for attending this session. I would also like to take this opportunity to thank LexisNexis for associating with our event as title sponsor. I also extend my heartfelt thanks to the members of bench, bar, academic institutions, all the law universities in India, students, and the members of press and media who have contributed to make this event a grand success. I also want to thank the participants of this first of its e-seminar, who will be sharing their shared their online presentations for the past 3 days, and we have completed this event today with the valedictory ceremony. I also like to thank each and everyone who is associated with Legis Orbis and who have put their sweat and blood to make this event possible and a grand success one. Thank you, everyone. Thank you, Justice.